Extension of time, CRS 1619-118. Extension of time, 1619-118. If the accused is not arrested under warrant of the governor by the expiration of the time specified in the warrant or bond, the judge of a district court shall either recommit him or her for a further period not to exceed 60 days, or again take bail for his or her appearance and surrender as provided in section 1619-117, but within a period not to exceed 60 days after the date of the new bond. Some annotation. This section, together with another one, imposes an outside limit of 90 days, although appellate was held in jail 39 days before continuance was requested. The court did have authority to grant a continuance. Second extradition proceeding not precluded by expiration of 90 days. Res judicata. Res judicata may not be invoked to bar a second extradition proceeding. An initial discharge and dismissal. Garcia v. Cooper, Colorado, 1986. That old Colo. Colo, 1986. Garcia v. Cooper. Dressel v. Bianca. Shum v. Nelson's also mentioned. Forfeiture of bail, 1619-119. If the person so held is admitted to bail as provided for in section 1619-117 and fails to appear and surrender himself according to the conditions of his bond, the judge of the district court by proper order shall declare the bond forfeited and order his immediate arrest without warrant if he is within the state. Recovery may be had on such bond in the name of the people of the state of Colorado, as in the case of other bonds or undertakings given by defendant in criminal proceedings. 1619-119.5. 1619-119.5. Custody pending arrival of agent of the demanding state. Custody pending arrival of agent of the demanding state. Upon ordering the delivery of a fugitive forthwith to the agent of a demanding state, a judge shall allow the agent of the demanding state a period of not less than 15 days and not more than 30 days from the date of the order within which to complete transportation arrangements, travel to the state, and appear to take custody of the fugitive. During this period pending the arrival of the agent of the demanding state, the fugitive shall remain in custody in this state without bail and shall not be discharged. Without bail and shall not be discharged. 1619-120. Persons under prosecution when demanded. Persons under prosecution when demanded. If a criminal prosecution has been instituted against a person under the laws of this state and is still pending, the governor in his discretion, subject to such criminal prosecution, either may surrender him on demand of the executive authority of another state or hold him until he has been tried and discharged or convicted and punished in this state. 1619-121. When guilt inquired into, the guilt or innocence of the accused as to the crime of which he is charged may not be inquired into by the governor or in any proceedings after the demand for extradition accompanied by a charge of crime in legal form has been presented to the governor, except as it may be involved in identifying the person held as the person charged with the crime. You think Heidi Ganahl or Jared Polis is going to win? They're all winning like by 20 points, right? So they're all probably going to win, and I hope so, but essentially it's either between a blowout or a landslide, right? A blowout loss or a landslide victory. Either they're going to fucking win, like Michael Moore saying, just a blue wave, or there's going to be a bloodbath red wave like is historically expected and has been, the expectations and the prediction essentially for the last year and a half. Is it going to be the bloodbath? Is it going to be a shellacking? Is it going to be just a little jab? A little 1-2 jab? Is it going to be a whimper? Is it going to be a blue wave? Is it going to be the opposite? A blue wave shellacking on them? Or a bloodbath on them? Or a little jab on them? There's some annotation for that. When guilt inquired into. The guilt or innocence of the alleged fugitive may not be considered in extradition matters. Self v. People, 1956. Look, you may be the most innocent person in the world, Jesus Christ. I hear you, Jesus. I still got to obey my orders. Look, I got my orders from Pontius Pilate. Pontius Pilate says I got to obey Pontius. I got to obey the judge. The judge wants to throw Frederick Douglass and J.C. Dugard and Anne Frank in jail. Who would arrest? Who would fuck up? The cops. Who would arrest Anne Frank and fuck up and Frederick Douglass and fuck up J.C. Dugard's case? The cops would. That's who would. Anne Frank. Why would you just throw a person in jail just for their religion? Just because they're stupid? This is America. We got a right to be stupid. You know what I mean? Ah! Guilt or innocence of the crime charge has no bearing on the issue of extradition, but will be determined on the trial of the case once he is returned to the demanding state. Fox v. People, 1966. Osborne Van Cleve. Osborne v. Van Cleve, 1970. When the court in Kansas forfeited the petitioner's bond, he became a fugitive within the meaning of the extradition laws. Whether it was wrongfully revoked is an issue between the petitioner and the state of Kansas, over which the courts of Colorado have no jurisdiction. Davis v. People, 1970. Governor may recall warrant 1619. 122. 1619. Criminal procedure is not applicable. What? North v. Koch, 1969. Governor may recall warrant. The governor may recall his warrant of arrest or may issue another warrant whenever he deems proper. Hey, you know, on second thought, Jeffrey Dahmer could just stay in Ohio. Let Ohio deal with the Jeffrey Dahmer. I don't even want to. No, let's extradite Jeffrey Dahmer. Tupac, for jaywalking, go ahead and recall that warrant. Courts of asylum state may not consider certain allegations. The courts of the asylum state in a habeas corpus proceeding under this article may not properly consider allegations that the fugitive's life would be endangered by return to the demanding state. The accused in respect to this matter must pursue his remedies in the demanding state or with the executive of the asylum state. Lomax v. Cronin, 1978. Demanding state may reinstate extradition demand after having withdrawn. Massey v. Wilson, 1980. Governor may reactivate the warrant. Jacobson v. Sullivan, 1985. Colo, 1985. 1619 123. Fugitives from this state. When the governor of this state demands a person charged with crime or with escaping from confinement or breaking the terms of his bail, probation, or parole in this state from the executive authority of any other state, from the Chief Justice or an Associate Justice of the Supreme Court of the District of Columbia authorized to receive such demand under the laws of the United States, he shall issue a warrant under the seal of this state to some agent commanding him to receive the person so charged and delivered to him and convey him to the proper officer of the county in this state in which the offense was committed. Fidelity and Deposit Company v. Hershey, 1933. People v. Quackenbush, 84. I like the old ones, 1933. Fidelity and Deposit Company. Well, according to Fidelity and Deposit Company, according to the Fidelity decision, Fidelity and Deposit Company v. Hershey, the chocolate company? No. It's a guy named Hershey. Oh. You got a Hershey's bar on you? No. We're in the middle of a deposition. Why would I have... I'm just hungry. You got any runts or gobstoppers or some nerds or something? 1619 124. Wouldn't that be the best judge and jury ever? All of them are just high as shit. Everybody's just chillaxed and high as shit. Man, you know how there used to be smoking areas? We should just ban cigarette smoking and just have marijuana smoking areas. 30% of Colorado are daily or regular users of marijuana. 30%. Probably including the governor. How can the governor issue warrants and recall warrants and reactivate warrants when he's high as shit? Because you can function. You can be a functional pothead. There's lots of functional potheads out here. You know what I'm trying to... Fugitives from this state. 1619 123. When the governor of this state demands a person charged with a crime or with escaping from confinement or breaking the terms of his bail, probation or parole in the state from the executive authority of any other state or from the Chief Justice or an Associate Justice of the Supreme Court of the District of Columbia authorized to receive such demand under the laws of the United States, he shall issue a warrant under the seal of the state to some agent commanding him to receive the person so charged if delivered to him and convey him to the proper officer of the county in the state in which the offense was committed. Interstate agreement on detainers is inapplicable to the defendant whose custody application for requisition 1619-124 when the crime of this immunity from civil process 1619-125 a person brought into the state by or after a waiver of extradition based on a criminal charge shall not be subject to service of personal process in civil actions arising out of the same facts as the criminal proceeding to answer which he is being or has been returned. Right, so you gotta finish the criminal shit before you get into the civil shit. It's like, oh, they caught the criminal, I'm suing you. We haven't even figured out the criminal matter yet, motherfucker. Wait till the criminal matter is fucking written waiver of extradition. If the criminal writes a written waiver, then the state of Colorado can't do anything about it. I'm just kidding. Isn't that obviously stupid? Let's see, 1619-131, escape, reward. If any person charged with or convicted of a felony breaks prison or escapes or flees from justice or absconds and secretes himself and secretes all over himself, it shall be lawful. Hides himself. It shall be lawful for the governor, if he judges it necessary, to offer any reward not exceeding $200 for apprehending and delivering such person into custody of the sheriff or other officers as he may direct. Upon the person or persons so apprehending and delivering any such person and producing the sheriffs or justices received for the body to the governor, it shall be lawful for the governor to certify the amount of the claim to the controller, who shall issue his warrant on the treasury for the same. 1619-132, interpretation. The provisions of this article shall be so interpreted and construed as to effectuate its general purposes to make uniform the laws of those states which enact it. Let me say that even slower. The provisions of this article shall be so interpreted and construed as to effectuate its general purposes to make uniform the laws of those states which enact it. Some annotation, statutes strictly construed, statutes providing for the arrest and extradition of fugitives being in derogation of constitutional guarantees of immunity from arrest must be strictly construed. Matthews v. People, 1957. Under Colorado law, the extradition statutes must be strictly construed as they are in derogation of the common law. Davis v. People, 1970, but not interpreted to allow asylum to offenders. Extradition provisions should not be so narrowly interpreted as to enable offenders against the laws of a state to find a permanent asylum in the territory of another state. Travis v. People, 1957. Tinsley v. Woods, 1957. Capra v. Baller B, 1965. Dressel v. Bianca, 1969. Boyd v. Van Cleve, 1973. 1973. 1619-133, concealment of fugitives penalty. That has been repealed. So, are you concealing the fugitive? All right, well, here's a penalty. No, hold on. This law has been repealed. Does that mean you're allowed to give sanctuary to criminals? Probably not, right? It's probably written some other places. I skipped over a couple of these. Long security for cost, default fees, prosecution for other charges, non-waiver but prior waiver, rewards, how audited, paid, escape, securing the attendance of a defendant who is outside the United States. That's interesting. And then extradition of persons of unsound mind. That's Article 20. So that ends my speech on Article 19, CRS 1619-134, fugitives and extradition.